Morning. So we're winding down. After the day, we have 2 more classes. Did you get your midterm grades?
Sorry, didn't hear you.
No,
I
I
said,
didn't get my midterm grade.
No, hold on. Let me ask Mr. Pratt what happened. Oh, don't worry. They were marked and sent out. And I was just wondering if you all want some multiple choice on the final exam.
I guess it could be a mixture.
You sure?
I don't know, but that I ain't sure.
That ain't sound too
That's
good. That ain't sound like that was a good situation.
But you know,
Mhm.
last week, some people say throw it away. Say
Yeah.
throw
Oh,
the exam.
yeah, it was
Okay.
a little tricky.
It was not tricky. On average, the
Not
average.
tricky. Not really tricky. I just like how somebody said, like the delivery of it. I don't know. Like I know, like when I doing multiple choice, I like to come back to what I ain't sure about, and the
Oh,
fact that everybody like was just we was going from page to page like that. It kind of wasn't
I see.
working for me.
Okay. I did mention it to Mr. Brock. He said he's sending the grades now.
Oh, jeez.
It's only midterm. Don't forget, I told you all I'll give you points for presentation. So I just have to go through and then add your points onto that. So I won't say anything about the grades.
What was the passing mark?
Well, and any passing mark is a passing mark, but I mean a good passing mark to get good points should have been at least 70.
Okay.
Oh.
So, what's the next question you want to ask me now? Should always be a follow-up question. What's the next question? Someone should say, did I get 70?
No, nope.
Nobody wants to ask?
I can leave that right.
No.
Okay, that don't sound too good. So y'all sure y'all want multiple choice on the final exam?
Uh,
Yes, no, maybe so.
I could say yeah. I could say
We
yeah.
have to
I
wait
mean,
for
even
everybody to
though,
get wait for everyone to get a general consensus.
yeah.
Okay.
I mean, me personally,
Then-
like yeah, because once we coming in for that, right? So
Mhm.
I could work at my pace and read properly.
I see, said the blind man. I see. But nobody got 70.
Huh? So
Mm-mm.
nobody passed this exam then?
Nope.
Oh Lord.
Yeah.
Oh Lord.
Glory. Oh, wow.
Nope.
So what portion of our grade this would be?
No, don't forget I'm going to add on points for the presentations.
Okay.
No, but that's still,
It'll bring it over 70.
Okay, thanks.
Whoa.
Appreciate it.
I did a lot of presentations, you know. You don't realize it, right? But you did a lot. 1, 2, 3, 4, 5, 6, 7, 8. 8 presentations. And so if I were to give each presentation 5 points, you see what I mean?
yeah.
And add that on top of the average grade, Everybody wants to know the average grade.
Yes,
Two.
I would like to know.
50 or 52
Wow,
out of 100.
powerful.
Very powerful. That's why I asked, you sure you want multiple choice on the final exam? Or you want to stick to the short answer?
I feel like you could mix it because I feel like like Senior said before, the way it was delivered was a part of it.
Okay. All right. Okay.
Yeah, I would say I mean, for me, I think I probably didn't take my time to read properly.
Okay.
Yeah, it was kind of fast.
All right. So how many we looking at? 10?
How many questions we
Okay.
having in the final?
Oh, normally I just give 5.
Huh?
5 short answers.
Wow.
What, y'all want more than 5?
You say the final exam must be 5 short answers?
Uh-huh.
But those five short answers is be, how much marks per question?
20.
20 marks. I thought as much. So I have to have everything in there plus blood type.
Yes.
Okay.
Yes. Don't forget, we discussing this now because next Saturday, I will be able to tell you which cases and the topics that the exam will cover.
What date is the exam?
The exam is on September the 24th. So you have, practically 3 weeks to study.
Sorry, Ms. Archer, I missed what the final mark was for passing grade.
Oh, we didn't discuss the final grade. We were
Oh,
just
okay.
in the midterm grade, the average
Oh,
grade.
the midterm grade, okay.
That's the midterm. See, what I always look at like this, when you have multiple choice, let's say I give 10, or it could be 20, or it could be 15. But let's just say if I give 10, 2 points each, and you miss 5. So many points you've already dropped down to,
Yeah,
versus if you get short answers and you would have read the cases and you know where the questions are coming from in the chapters, then you'll have a better idea of, okay, if I'm dealing with this is the case, because you'll go through the cases, because I'm not going to tell you which case goes with each question. I'm just going to give you the cases. And then, like I say, we would have read them before. So when you read the scenario wouldn't be verbatim Scotiabank versus Cube Enterprises. But when you read it, you will say, oh, that's Scotiabank versus Cubes.
gotcha.
Yeah. But it's up to you all. So let me give you a couple minutes now because I have my final exam outline right here to tell me what to write. Let me know what you want. Because then
I
I'll
think
go.
we better stick with them short answers.
Yeah, that's what it sounded like.
That ain't
Hey,
what it's.
unless them multiple choices bonus, yeah, the short answers.
Yeah, we'll stick with the short answers.
Okay, all right. So I'll put here short answers.
We ain't trying to fail twice.
For
Oh.
real.
I put down short answers. It ain't gonna be that bad. I won't kill you. But there's certain things you expect. Oh, and I'd also tell you the legislation that you should know, which I think you all know already. Which one you think is going to be on the exam that you will have to apply?
Homeowners.
Yes. See? So on your study pack, that's the first thing you put down. When you finish today, the next one you will put a little tick to would be the Environmental Act. And then I'll think about the construction one. All right, so let's go. So for all those who, how many cases did you all read this week? Based on those you had missed? Everybody up to date now? But you still have some to read.
Still have a
I
couple
still
to
have some
finish.
to read.
Yeah.
Okay. All right. Long as we get there. So when I say which ones, you don't have to panic, like I say, and be reading it for the first time. Because when you read it and you panicking, you don't remember. So we'll go from there. All right. So let's start with the duties and liabilities of realtors and contractors. So this module 10 goes with two pieces of legislation. The Construction Contractors Act and the Environmental, what they call it, the Environmental Planning and Protection Act and the Environmental Impact Assessment Regulations. Anyone could tell me before we start, what's the connection between those pieces of legislation and mortgages? Anyone? Just thinking about it. Has anyone read them before? Those two pieces of legislation.
Miss Archer,
Yes.
I ain't gonna tell you no lie. I got that email. I did not read any of it because I thought I had until Monday. So I humbly apologize. I didn't read any of them.
That's fine, that's fine. But I'm saying this, listening to the headings. One is the construction contractors, one is the environmental. How do they relate to mortgage, the mortgage process? How do they tie in?
I
Dealing
guess
with
with the
construction loans,
construction
eh?
one,
Yeah.
yeah. When you're
Mhm.
building a home, it pertains to when you're building a home, I would say.
Yes, and the next one?
Based on, I want to say.
The land,
utility,
I guess, part of it.
Then
How it impacts the environment.
Mm.
Any environmental resource or concerns, I guess.
Yes. And have you been following those notices in the paper?
I don't get papers, sorry.
no,
No, mom.
Oh, I have to say, like my other class, you Bohemians, I don't know what is wrong with you. These
Oh, my-
things are published in the papers for a reason.
Yeah, you get the physical paper or you just read that online?
No physical paper.
Yeah, I am Freeport. I don't get the physical paper.
So when you get the electronic paper, what do you get? Just the headlines?
Yeah, you see the headline probably electronically, so you don't get the entire thing.
Mm. So then you don't have an idea of the various projects that required approval.
No, mom, I have no idea what you're referring to.
Oh Lord, this is not good.
What section that normally be in? So thanks, so I can look out for it next
It's
time.
not any section,
And it's be all through the newspaper.
right? You'll see a little small square that says public notice. But anyhow, when I get to the legislation, I'll tell you what it says. And then I'll give you all a link that y'all can go on as we go through the legislation. So you could appreciate it. Because it's very important as a citizen to know what is happening. Because once that project is finished, that's it. And then we get to the Construction Contractors Act, then I'll show you, well, highlight some of the requirements that you should be aware of. Okay, so when you're talking about realtors and contractors, you know that they base all of their business on contracts. We know for the realtors, there's a sales agreement. And we know for the contractor, there's an agreement to build a house in stages. So the law that governs those two, realtors and contractors, is contract law. So we're not talking about mortgages itself now and the law of conveyancing and the Homeowners Protection Act. We're now talking about two of the stakeholders that are part of the mortgage process, realtors and contractors. And they operate under contract law. So in order for there to be a valid contract, you must have offer and you must have acceptance. Someone must make an offer and someone must accept. In addition to that, you must have consideration. Consideration is either the act being done or monies are paid. So in a realtor situation, if you sign a sales agreement, there is a deposit required. That deposit is the consideration. The fourth, in order to say that you have a valid contract, is that there must be an intention to create legal relations, which means that the parties must have been of the same mind that they wanted to enter into that agreement for whatever purpose that they have agreed upon. And the fifth element, in order to have a valid contract, is that the parties who are entering into the contract must have the capacity to do so, which means that they must be 18 years or older and they must be of sound mind. If it is a company, the company should be of good standing. Good standing means that at the Registrar General, it has paid all of its fees. So normally for a company, you ask for a certificate of good standing. And the second document you'll ask for is a certificate of incumbency. And that tells you who owns the company, who is on the board, how many shares it has, who is its registered agent, and where its registered office is. So those 5 elements is what determines whether or not you have a valid contract. Now, in addition to that, especially when there is a dispute, the court looks at other things. One being formation. They look at how and when the contract was created. Then they look at the validity, whether or not the contract itself is enforceable. And what that means is that you cannot enter into a contract for an act or for a product that is illegal, because that is not a contract. Even though it would follow all of the elements of a contract, if the substance of it is illegal, then it is not a contract. Next, they look at the terms within that contract. So remember, in every contract, there's always the duties of either parties in order to effect the completion of the purpose of the contract. And so the courts look at the responsibilities of either parties, the obligations, the termination clause, the duties, the legal liabilities. They look at all of those clauses just to make sure that it is clear, and one, that the person who wrote the contract did not write it unfairly. The next thing you look at is discharge. How can the contract be terminated? And in most contracts, you would see there is a termination clause. In some instances, there is a fee or penalty if you terminate early. Or there is a penalty if you don't give sufficient notice, and the notice is stipulated in the contract itself. And of course, whenever you're dealing with a contract, there are always remedies. And remedies means that if there is a breach of the contract, you can seek damages, or you can, if damages is not sufficient, the court can award an equitable remedy to try to compensate you for in lieu of damages. Or another remedy can be that the court can terminate the contract. And the last one that the court looks at is the limitation. That is when the action can be taken on the contract. So all in all, when you're dealing with a realtor or you're dealing with a contractor or any other stakeholder in the mortgage process, those are based on contract law. And last but not least is privity. And privity means that if you're not a party to the contract, you cannot bring an action. Only those who are party to a contract can bring an action. Any questions? Clarification? No? Does everybody understand contract? What's a contract and how it works?
Yes.
Okay. So if you have a contract and now you want to discharge that contract, and there are 4 ways to do that. The parties could just agree that they want to discharge the contract. But in order to discharge it, there must be consideration. And remember, I said consideration is either the act is done or monies are paid. Another way you can discharge a contract is just to perform. In the contract, you would have had the obligations and the duties of either parties. And once you complete your duties or your obligation under the terms and condition, then the contract is discharged. Now, of course, you can have a breach. And that's where one of the terms of or conditions have not been met. The person who is aggrieved can sue. Or the person who is aggrieved can say, guess what? This contract is discharged. I'm terminating this. We can't go any further. And another way a contract can be discharged is if it is frustrated. And frustration means that it's incapable of being completed. So let's take Hurricane Dorian. If a contractor was in the middle of construction, then a hurricane came, took everything away. There's nothing left. Then you would say that that contract was frustrated. It was outside of his control. There's nothing he could do. Sometimes that happens if one of the party dies or there is injury to one of the persons who's required to perform the contract. Or it could be where you are building a resort and you need certain material in order to finish the construction. And you found out now, like how we have the war in Ukraine and we had COVID, there's a supply delay, there's a supply shortage. And if the developer has a timeline with the bank to make payment at different stages of the project, and now you don't have the supplies to finish it to meet the deadline for the persons who would have given their deposits for condominiums in that resort, then of course you can claim that the contract has been frustrated. So there are remedies for breach of contract. And the most common one is damages. The person can say, because you can't complete this contract, or because you gave me shoddy work, I am going to sue for damages. Or they can ask for an agreed sum, which means that this is what I paid for my material. This is what you installed, and I want the difference. Or you could ask for quantum merit, which is as much as it is worth. So you're asking for the value of what should have been done. Now, in some instances, when you go to the court, you can ask the court to exercise its discretion using equitable remedies. And this is normally done when damages is not sufficient. So you could go to the court and say, guess what? This contractor is not following the guidelines. He's not following what we agreed. Then you ask the court for specific performance, which means you want the party to stop. Or you could say to the court, guess what? This contractor started. Now he's busy doing 4 other projects, and I have a timeline and he hasn't finished. So I need him to come and complete my building. Leave those other 3 and 4 alone and come to mine, because we have a contract, we had a deadline, and I am past my deadline penalties. Or you could ask for an injunction. And that means stop them from doing something. You don't like the way the work is being done, and it's costing you too much money. And so you could go to the court and say, I need them to stop. And a rescission, and all that means is the court just says the contract is at an end. And what they do is they put both parties back to the position they would have been in had they not entered into the contract. And of course, rectification is when the court tries to correct a mistake that was made. So when you talk about realtors, we have 2 categories here. We have agents and we have brokers. So BREA has made it clear that the use of the designation realtor is limited in scope and is only reserved for persons who are qualified to be realtors. And the word realtor is a copyrighted trademark of the National Association of Realtors. So NAR has successfully taken their sole right of its use all the way to the US Supreme Court, and any member of an affiliate association such as BREA is entitled to join NAR. Then and only then will you have the right to use the word realtor. Unless this applies to you, then you are breaking the law when you refer to yourself as a realtor. That's when they put that little R with the circle. BREA licensed agents are welcome to join the Council of Certified Residential Specialists. This alone doesn't give you the right to use these designations. You have to complete the coursework and the electives and an application form and receive your confirmation of your designation before you could use that designation with your name. Real estate agents often act on a contractual basis with the vendors or purchasers of property in a real estate transaction. They're paid commission normally on the gross price for the sale, purchase price of the property, which are earned when the cash is deposited and or a written agreement has been made between the vendor and the purchaser. The real estate broker is permitted to charge and to collect a commission on the total cost to purchase the property at a private sale, auction, or foreclosed sale. Real estate agents and brokers are registered under and governed by the Real Estate Brokers and Salesmen Act 1995. And that outlines the registration process for real estate brokers and salesmen. It regulates the real estate practice, professional misconduct, and disciplinary action, and the requirements in relation to handling real estate transactions. So a real estate agent fees is 10% for vacant land and 6% for non-vacant land. The general duties of a real estate broker is they have a duty to follow and act on their client's instructions. Because once they enter into that contract, then they enter into a principal agency relationship. So they have to follow their client's instructions and do it in a timely manner in accordance with the terms of the contract. They also have a duty to act in good faith and are, as always, in the best interest of their client. They have a duty to act in a professional manner. And they have a duty to account for all monies paid to and entrusted to them for deposit in a property transaction. And their last duty is a duty to disclose any conflict of interest in the execution of their duties. Any comments? Anyone interested in being a real estate broker?
No, ma'am. No, ma'am.
No,
No.
it's a lucrative area.
Yeah, but it's two-way fee. It ain't constant.
I see
And
the trick.
sometimes the closing fees and the closing of homes and stuff, sometimes it take a little long, so.
Yeah, they do. But when you're on a roll, I think it's clientele, having that network. Once you have that network, your clients keep coming in. But without a network, it'll be very difficult. You can't just be a solo person. You have to be an agent of one of the large firms. Otherwise, it's very difficult. So in this process, we just spoke about real estate agents. Now, one of the other things is that when a foreigner decides that they want to invest in the Bahamas, you know that they have to go through NEC. And NEC then decides whether or not they agree to permit a person to come in and carry out a certain project. So there are two things that's happening here. Two pieces of legislation: the Construction Contractors Act and the Environmental Act. So let's look at the construction first. Because in order to carry out your project, you need a contractor. So the Construction Contractors Act provides for the registration and the licensing of construction contractors. It regulates their conducts and practices. And it also has a disciplinary board for complaints against dishonest or unscrupulous contractors. And there are penalties for infractions. And there's a rating system for scales. So when you go to the act, and this is for the contractors now. Contractors have to be registered. So it says an individual is entitled to be registered in the contractor's register. But in order to do that, he has to satisfy the board that he has obtained the following criteria relevant to the category to which he is applying for. So there are different categories in the act if you're an individual. I'll just name a few. If you're an individual and you're registering as a general contractor, an elevator contractor, a commercial building contractor, electrical contractor, a masonry contractor, a roads contractor, a roofing contractor, painting contractor, building contractor, swimming pool contractor, and there are others. You're required to have certain qualifications. A bachelor's degree, Bachelor of Science degree in a construction-related area from an accredited college, and 2 years proven experience under a licensed contractor, and one of which must be at the level of foreman. Or you could have a 3-year diploma or associate degree in construction related area and 3 years experience under a licensed contractor, and one of which must be at the level of foreman. You can have a 1-year certificate in a construction related area and 5 years experience under a licensed contractor, and 2 of which must be at the level of foreman. Or you could have a high school diploma and 10 years experience as a skilled tradesman, 3 of which must be at the level of foreman under a licensed contractor. Or you could have passed an exam set by the board or recognized by the board or set by another licensing authority, and it demonstrates that you are proficient in the construction related industry and you have 5 years working experience in the industry. In addition to that, you have to be fit and proper to practice as a registered contractor. And so that means that you have to have an affidavit verifying that you have a relationship with a local bank within the Commonwealth of the Bahamas. You have to submit yourself to a background check. And you also have to comply with the requirements under Section 11.2. And that states that every individual who is not a Bahamian and who makes an application for registration must obtain all necessary approvals prescribed by the NEC. So these are the requirements for a contractor to be registered under the Contractors Act. Were you aware of this?
We have plenty of licensed contractors around here.
But the law is quite clear. They need to be registered. So an individual who wants to be licensed as a contractor in any year must apply to be registered as a contractor in the contractor's register, satisfy the qualifications, which I just read out to you, and pay the requisite fee. They have to submit to the board a certificate of registration. They have to produce documentary proof to the board that they are an existing client at the bank, like I said. And of course, added to that, they have to produce public liability insurance of a minimum of $1 million. So a firm which wishes to undertake work as a contracting firm, they also have to apply for a license. And in their application, they need to say who is to be named on the application and who has the authority to bind or to submit bids on behalf of the company.
They have
Who's-
to submit, sorry, they have
Mhm.
to have $1 million public liability or professional indemnity.
Public liability.
Okay, because I know I get calls sometimes for contractors who need professional indemnity insurance. And then once they're doing or building, constructing a building, then they get and the contractor's all risk policy, they have the public liability in there. But most times they ask for professional indemnity insurance.
Builders access, they have to have public liability insurance of a minimum of 1 million. So
And I think maybe because in the insurance industry, it might have kind of changed because we don't sell public liability as a
by itself.
right. So you can't do it like to say, just get a public liability policy to last you the whole year. It's on a case by case basis.
Mhm.
So,
Well, I
I mean,
know
I
what-
know the ARC has been around a while and I'm sure they didn't have
Yeah, this was done
consultation. Yeah,
2016, and
okay,
I don't think they have amended it.
yeah, okay.
Yeah. But even though it says public liability insurance, if on the insurance side, it's a part of all risk, it's still covered, it still meets the requirement.
Yes, because they usually get, yeah, they usually get, minimum they get is like 500,000, depending on the size of the contract.
Right. So what else they say here? So if it's a company, they must have a current business license. Like I say, they have to give you the name of the persons who have the authority to submit the bids on behalf of the company. The licensed contractor has coverage under the Builder's Defects Compensation Scheme. And they must be able to provide proof that the individual is able to obtain the public liability insurance of 1 million. And then anything else that the board may require.
So is this regulated? Like, do they go around and check to make sure if they see someone constructing a building or something? Or does this really come into play in the event if you have to go to court now and then you find out, okay, this person is not a licensed contractor?
But don't we have people who that go around when you're building who come to inspect?
That's what I was about to say too, like, what is the permit process? Like, does the contractor get don't they get the permit? Like, in them getting the permit, isn't it some requirements that they have to go through to get a
So they have-
permit? to
So they
begin
have to
building?
submit those stuff to Ministry of Works then?
Yes. Mhm.
No way. No,
Yeah.
building permits are approved when you approve your plans, you know. That's not on the contractor. That's the owner
Oh.
really when they submit their plan. So the permit comes with that number.
That's-
That number
that's
comes
right.
with the plan. So for the contractor, and then when you look at it, when in construction, Ministry of Works only goes out to inspect certain stages, foundation, and I think maybe up to belt or the roof, and that's it, they're gone. And I don't think it's where they are actually looking to say, is this contractor registered or they have a license? They don't do that. They're only making sure the working shorty. And they just write up their receipt and they go with their business.
But I mean, as well, like with the bank too, I think, well, if you're going through the bank, obviously the bank actually has an approved contractors listing. And I think that's probably how you would be secure in that way. Now, if you're doing it on your own,
They have a secure, I
guess.
mean, they may have a listing, but do they insure and say every year
That these
you have
persons
to
are,
bring in your license and they are
That's
in
up to date.
compliance with the law?
I
As
don't
for
know.
us, the credit union, we do that, and they have to have 1 million and over.
Mhm. And are they registered with the contractors board?
We ensure that they all are registered. And in fact, when members come and bring their contractor, if they're not on our list, we also recommend that they use someone off our list. And if they choose not to, then the liability is on them.
Mm-hmm, mm-hmm. Yeah. So it built into the legislation is the point that I just made to you on, where is it? There's a requirement. Okay. That the licensed contractor has coverage under the builder's defects compensation scheme. So what is that? What they've done is they have appointed a scheme manager. And that scheme manager is responsible for administering the builder's defects compensation scheme. So that the participation in the scheme by the builder would cover his defective workmanship as a builder in relation to a newly constructed residential home of a homeowner under the code. So there's a scheme manager, their duties is they deal with claims from the homeowners or his agent in relation to the defective workmanship of the builder of a private residential home. They receive all the claims from the homeowners and they report claims received from the homeowners to the claims committee. And then they pay out any funds from the fund in relation to the correction of any defects by the builder. So it says here, only a residential home covered by the scheme shall be covered for losses, and such coverage shall be granted to the builder by the scheme before the construction of the residential home. And the scheme shall apply to a private residential home with an estimated pre-construction value of up to $500,000. And the builder shall be covered by the builder's defects compensation scheme for defects in the construction of the residential home up to 10% of the value of the home, which is up to a maximum of $50,000 in coverage for defects.
Just ask, you think people is buying into that?
I don't know. Listen, we have a lot of laws on the books that we don't use.
Because this is the first I ever hear about something like this.
Yes, this is in the legislation. It says right here, this is section 15, license of registered contractor, subsection 3. And it says a firm which wishes to undertake work as a contracting firm in any year shall apply to the board for a license. And then these are the things that they have to state. One of them being that they have coverage under the builder's defects compensation scheme. Yes. And the board, the contractors board should have set a level for the premium. And of course, once you are licensed, a licensed contractor, you can advertise in the newspaper or in the media, the telephone, and on any correspondence. And a licensed contractor also has to specify their license number in any form submitted to the Ministry of Public Works when they are requesting a public permit, inspection, certificate of occupancy, and shall tender together with the forms evidence that the license is valid. So then, like we were saying just now, when you have a contractor on your list at the bank or the credit union, you have to make sure that they are registered and that their business license is valid. Now the board, we can renew the licenses annually once they pay the requisite fees. And that's by the 31st of January every year. Oh, see it right here. The public liability insurance in the amount of 1 million, as well as contractors all risk insurance if required. Now there is discipline under this act for contractors for professional misconduct. And that's one where they are negligent or they fail to make reasonable provisions for the safeguarding of life or health or property of a person who may be affected by the work that they carried out, failure to correct or report a situation that they believe may endanger the safety or welfare of the public, failure to make responsible provisions for complying with applicable laws in connection with the work that they're undertaking, failure to present clearly to their employer the consequences to be expected from a deviation proposed work. If his judgment is overruled by a non-technical authority, undertaking work which he is not competent to perform by virtue of his training or expertise, conduct or an act relevant to the practice of construction, contracting which, having regard to the circumstances, would reasonably be required by the construction contracting profession as disgraceful, dishonorable, or unprofessional. Failure to abide by the terms or conditions of his certificate of registration, permitting counseling or assisting a person who is not registered nor licensed under the act to engage in the practice of construction, procuring his registration by a statement which is false, repeated performance of defective work to which adequate checks have not been applied, and making any report in connection with the performance of construction contracting containing any information which he knows to be erroneous in any material particular. Being otherwise guilty of negligence or incompetence in the performance of his functions as a contractor, or unjustified refusal to remunerate the services of any person contracted by the contractor to carry out work on that contractor's behalf. So all of this means, all of these are acts of negligence. And that could be the act itself, or it could be by omission. And all of that constitutes a failure to maintain the standard which a reasonable and prudent registered contractor would maintain in the circumstances. So a complaint that an individual registered under the Contractors Act has been guilty of professional misconduct may be made to the board by any person in a prescribed form. And that should be accompanied by affidavits. And then from there, the next step is, goes before a disciplinary committee. And that committee has the power to remove the contractor's name from the register. They can be suspended for a period not exceeding 1 year. They could pay a fine of $5,000, or there's payment of costs or of such sum as the board may consider towards the cost incurred in connection with the proceedings. Of course, you know, the board can invoke immediate suspension, or they could remove the name from the register. So once a name has been suspended, any certificate of registration or license issued to the contractor shall cease to have effect for as long as the name remains off the contractor's register, or the suspension continues in force. Where the name of any individual has been removed from the contractor's register, the board in writing requires that individual to return to the registrar his certificate of registration and license, and cease using the license number in any correspondence. And of course, a contractor can be restored to the register if the board thinks that that person is fit. They can put them back on the register. So those who didn't have the time, you could read the Construction Contractors Act. So what are the general duties of a contractor? They have the duty to follow, just like the broker and agent, their client's instruction. They have the duty to act in good faith. They have the duty to build or construct the dwelling house or the building in a safe, secure, and professional manner. And they have to take into consideration all the relevant health, safety, construction, structural, and other risk. Remember, the act just finished saying that if a contractor hires someone who is not trained to do a particular function, and he puts the owner at risk, then of course, he can be brought before the board for negligence. The duty account for all monies paid to and entrusted to him for the construction of the dwelling house or the building, and to use the money for the purposes for which they were advanced. A duty to disclose any conflict of interest in the execution of his duties, and the duty to exercise good workmanship in the construction of the building. And that's required by law. Any comments? Now that you know that this law is in effect? No?
I just understand that if we would use the laws that are on the books, we would eliminate a lot of issues we have around here.
Yes, I agree with you. But why you think that is? Why don't we? We have them. This
I
is
think
just,
people are deterred from doing it because sometimes the things just take so long and they don't want to go through all that long drawn out process. And I think that's a deterrent for most things.
but do you know in other jurisdictions like South America, all of this is automated? The whole process. Everything. And let's say if you're building let's say some condominiums, a lot, and you go into the bank now for stage 2 or even stage 1. They even have the software already designed where you put in, the contractor tracks every penny that he spends on this software. And every part of the job that's outsourced to another company, they would key in the name of that company and that person's license and the expiry date and the amount that they spend. We could have been there by now if we had started years ago and just build on the software. But every contractor, as he gets to each stage, he presents a report as to how much he spent and what he spent it on. Detailed.
Ms. Archer, now you know we can't do that.
But I'm saying
Friends,
it is,
family and lovers could be mad.
but that's how it's done.
And
how
that's,
it's
and that's,
supposed
and
to be
that sounds like a very good way to do it, where you are ensuring that you are not being chipped and your monies are being used the way it should be used.
And
I
then
agree,
when,
that would be very transparent.
yes. But isn't that what we're trying to work towards? Transparency?
Only in certain things. Miss Archer, only in certain things.
But this is what we have to work towards if we want a better place.
I ain't saying no lie. It
I
sounds good in
know.
principle. It is really sounds good in principle. But when we talking
But
about the
work-
culture, our culture just, I mean, it sounds good. And of course, this is where level-headed thinking behemoths would want the country to reach to that level. But it sounds good, but we know the culture have to change before we get there.
That's sad. That's sad. It's sad because this legislation has been on the books from 2016. In 2022.
And all the lawyers in the House of Assembly.
Exactly. Exactly. And each one is under a particular ministry. And I'm sure the permanent secretary can say, these are the laws that fall under our ministry. Where are we now? Do they need to be updated? What do we need to put in place? But what are they doing? Hiring more humans rather than teaching them how to fish. They're hiring more humans, not putting in technology. It is sad. It is sad. But that law is in place. So now, let's just say now, you go to the NEC and you have a project. So let me give you the name of a project. Hold on 1 second. I have it right here. The latest one that's in the paper. You have your computer nearby, or you could go on your phone. www. Torchkey, torchkey.com/environmental. Someone else could, if you want to, could go on another one. This one is,
This Torchkey is Exoma.
yes, ma'am.
Okay.
Yeah, you have to read the whole paper. But I don't understand. Well, how come Freeport doesn't get the whole paper? That no one sends it over, even if you get it late?
Probably. No, I don't see it.
Yeah, but
Even
then,
if,
go ahead.
come on. Does the newspaper
Yes, ma'am.
still come to us?
The managers, we don't get newspapers no more.
That was discontinued, right?
Yeah.
All right. I don't know why I don't see nothing over here, Ms. Archer. I don't even see the Guardian.
So how do you know?
But I'm
How-
sure they deliver it over there, Demetria.
They
Where
have
is
to.
deliberate?
Because I know when I go early flights to Freeport, so you'll see the newspaper coming over on the flights.
So they probably sell
Ah.
it somewhere. But you all gotta buy at least a Guardian and a Tribune so you can see the notices.
Yeah, no.
Remember
I'll
when
ask.
remember when we did units 1 and 2 and we
Yes,
spoke
ma'am.
quieting,
Quieting titles.
right?
After
Those are also in the paper
Paper, yes, ma'am.
and that's
I'm
public.
familiar with it. I just,
Yeah. But you could buy a piece of property on another family island and don't even know someone has quieted it
yes.
because it's published in the papers. All right, so let's just say now you finish, you bought the property. Now you want to start this project. If it's a foreigner, they go to NEC first. Then after they have the NEC approval, the next thing is they go into the bank to borrow some money. They either borrow locally or they borrow internationally. But in order to get this project approved, before they could begin, a decision has to be made whether or not it's going to impact the environment. So before they could do anything, they have to have what they call a certificate of environmental clearance. If they commence that project without that certificate of environmental clearance, the fine is $500,000 or 1 year in prison or both. If they are convicted, then the fine is $10,000 or 3 years in prison or both. So let's look at what the procedure is to get this environmental clearance certificate. So any person who intends to carry out a proposed project has to make an application for a preliminary review of the proposed project. That's the first step. So they would fill out an application form with a fee, a non-refundable fee. So the director receives the application, then the director will examine it and cause to be examined the documents, and they look for accuracy, and then they make a determination whether or not the project needs an environmental impact assessment or it needs an environmental management plan, or whether further studies are required. If the director feels that the information that is being sent in is not sufficient for them to make a decision, then they would give notice in writing to the project proponent, asking for more information in order for them to consider and make a decision. So whether the director considers it necessary to submit either an EIA or an EMP, the project proponent has to prepare and submit electronically in writing an EIA or an EMP. The director shall inform the project proponent of his decision within 60 days of the date of submission of the completed EIA or EMP. And the director has the right, then he could ask for more information or he could ask for additional studies. Where the director is satisfied that a proposed project doesn't require an EIA or an EMP, the director can then issue the certificate of environmental clearance. Now, if the director says, yes, you need an EIA or an EMP, then director will advise the project proponent of the process to be followed for the preparation and submission of an EIA or EMP. So once the EIA or the EMP has been submitted to the director, the project proponent shall put a notice in the paper. And in that notice, they would state the consultative process that has been put in place by the proposed project. They will say that an EIA or EMP has been prepared, that the EIA or the EMP has been submitted to the department for review, and they give you a date, a time, and a place where a copy of the EIA or EMP may be inspected free of charge. So let's take last week in the newspaper, it says public notice. The public is advised that the environmental impact assessment for Torch Key, Hog Key, Exuma, has been filed by PMR Bahamas with the Department of Environmental Planning and Protection, DEPP. Torch Key is a private island development featuring private residences and a resort with associated amenities. A public meeting will be held Wednesday, August the 24th, 2022 at 6 p.m. The St. Andrews Parish Community Center, Georgetown, Exuma. Virtual meeting. And then they give you the Zoom link. The EIA can be reviewed online, and that's what I gave you just now, the link. Or you can actually review it in person at the Department of Environmental Planning and Protection, located at Charlotte House and the Island Administrator's Office in Georgetown, Exuma. The public can send written comments to inquiries@dep.gov.bs or environment@torchkey.com. So when you look at the environmental assessment, you'll notice that they cover all of the areas. They talk about the project design, the stakeholder engagements, the economic impact, and they also talk about the sustainability of the project. They'll also give you information on the findings based on their impact assessment. So what does Torch Key say? Anyone read the one for Torch Key?
You want the public notice?
No, I read public notice just now. I said, what's the impact?
Project summary.
They having a public meeting. So what's the impact of this resort that they're building?
Environmental report,
Mm-hmm.
environmental impact assessment. Oh, Ms. Archer,
It should be a summary.
there should be a summary somewhere.
Yep, it should have a summary. I can read you the one that I had done for the Lighthouse Point. That was another one. That was Atoll Island.
Mhm.
It says environmental impact findings. No unique marine habitats or species have been documented to occur within the proposed development footprint compared to other areas of Eleuthera or the Bahamas more broadly. Based on the surveys using the globally recognized Atlantic and Gulf Rapid Reef Assessment, coral reefs do not appear within the footprint of the open trestle pier or marina, including 75-foot buffers on both sides of the pier. just over 1/10 of an acre of individual corals could be potentially impacted and will be mitigated. Nearby patch reefs, considered to be in fair condition based on AGRRA surveys, are outside of the project area by more than 500 feet and will not be directly impacted. The impact to terrestrial species is expected to be minimal given the low density nature of the project. The soil ponds on site will not be developed. Some historical ruins were found in an area of the property where no development is planned. So they'll give you a summary of the environmental findings, and then they'll also give you an economic impact assessment. So in this one here, Atoll Island, they said over 25 years, the project is conservatively expected to provide a more than $800 million increase in Bahamian GDP. It will create at least 150 construction jobs, at least 150 operational jobs, give priority to Bahamian tour operators and entertainers, and provide space for Bahamian vendors on the property for the sale of their goods and services, among other efforts. And why I say this is something that Bahamians should watch, because based upon these environmental impact assessment reports, over time, you should be able to see whether or not these are actually accurate. So you have the Torch Key, you have Atoll Island. Another one was Great Stirrup. This was a public meeting, was held on August the 9th at the Great Harper Key Berry Islands Community Center. And this was another project that was being done. So all of these, as Bahamians, you should read these environmental impact assessment reviews. Do you know the difference between the impact assessment? What is that? The EIA. So what it actually does is just looking at the impact of the development projects and just to decide whether or not the project should be authorized. So it looks at the potential environment and then also the social and the health effects of the proposed development. And then you can make an informed decision of the likely consequences before you start construction. So it gives you an informed, they help you make an informed decision and trying to reduce or mitigate any adverse impact by the construction of the project. So the publication, the public consultation is for 2 weeks. And the department shall forward all of the comments received to the project proponent. So you'll see at the bottom of the public notice, it says that you can send it directly to the project proponent, or in some instances, you'll see where it says you could send it to the Department of Environmental. And then also you could send it to the proposed proponent. So during the consultative process, the project proponent shall provide detailed information concerning the proposed project and the potential environmental, social, economic, and cultural effects, any impact to adjacent properties, and any significant impacts on adjacent properties and the community. And then, like the notice says, they have to have a town meeting and they have to make a written record of all the concerns that are raised at the meeting or sent to them via email. So once they have satisfied all the requirements for a certificate of compliance, means certificate of clearance, a certificate shall be granted and it should specify any environmental clearance conditions to be complied with. The director shall inspect or cause to be inspected the activities being called out in respect of a project for which a certificate of environmental clearance has been issued, to determine whether the project is being carried out in compliance with the certificate of environmental clearance. And of course, if the project is not being carried out in accordance with the certificate of environmental clearance, the director can cause for the decommissioning of the project, the demolition of the project, the removal of any structure that was erected. They could direct the return to natural contours and conditions of all land, terrestrial or marine areas associated with the project. And they could stipulate any direction to be followed in respect of the activities. So after the certificate of environmental clearance has been granted, the department will continue project oversight to include, but not limited to, the designation of a case manager. So remember that also. If the project required a certificate of environmental clearance, then that project will have a case manager. And they're responsible for overseeing the project and ensuring its compliance with the EIA or the EMP. And also any conditions that were placed on it via the certificate of environmental clearance. They're also responsible to document the progress of the project and its compliance. And they have to give the final sign off upon completion of 3 years of full development operations. So these same EMPs, including the environmental clearance conditions, they have the project proponent has to follow those step by step because they are monitored by the department. If there is any lack of compliance with the requirements in the EMP or the environmental clearance conditions, then those deficiencies have to be addressed. The project proponent has to deposit a bond, and such bonds will be held in security to cover probable costs associated with environmental damage. And that bond is 5% of the value of the project, no more than 5%. It can be paid in cash and deposited to the Environmental Administration Fund, secured by an indemnity insurance, which shall be assigned to the department until the activity to which the bond relates ceases, secured by a guarantor through a reputable financial institution. The period of the performance bond would be for a period from the start of the project and for 3 years of full development operations. If the bond is not used after substantial completion and 3 years of full development operations, the proposed project is not in arrears with the department, the bond will be returned with interest that was accrued. Aren't we generous? In the event that the bond or any part thereof is used during construction, the unused portion of the bond will be returned to the project proponent, and the interest accrued is retained by the ministry. So the director for this environmental impact, they have to establish a website. And on the website, they will publish approved EIAs or EMPs after they issue the certificate. Any questions? You didn't realize so much is involved, right?
Yeah, it's a lot.
It is a lot. But it's just telling you that this whole process is changing. Because we have to protect our environment. Otherwise, we won't have sun, and sea. So normally that environmental impact assessment, that's more comprehensive. Because I think all of these I've seen so far in the papers. Two of them were impact assessment, and Atoll Island was an environmental management plan and an environmental baseline assessment. So it depends on where the project is and what's being constructed. But all of it relates to the environment itself. Any questions or comments? No? Silence gives consent. All right, so next class we'll do module 11 and we're looking at legal and credit risk for property and mortgage transactions. And then after that, we'll do the last chapter. Which is on ethics. Okay,
Yes, ma'am.
Okay.
all right. So if there are no questions and comments, I would say have a great weekend.
Thank you. You too.
You too, thank you.
Okay, make sure do some reading now.
Oh, Miss Archer,
Yeah.
the case study is when we getting them? I mean, when are you gonna tell us which ones?
On
for-
Saturday. Next
Pardon?
Saturday, the
Okay,
last class.
okay,
Yeah,
All right.
on the last class, I'll tell you all the area, the exam, the areas where the exam is coming from, and I'll tell you which cases you need to be familiar with.
okay,
Yeah,
thank
So-
you.
you don't have to know all of them.
Okay,
So
That's a
Ms.
few.
Archer,
Yes,
you're not giving any of the grades a, even though you say it was poor.
I did not, did I use that word? I did not.
Okay.
No, yeah, you didn't have to use the word. It's the numbers which you tell us both.
Miguel said he emailed it, check your email.
No, ma'am,
Many-
I ain't nothing yet.
Any email there?
He told me, listen here.
I
Miguel
ain't get
said,
nothing
to
yet.
me- he
you
said to me,
Now and
I sending them now.
When?
I tell him right now, the students are waiting. Tell them right now.
Okay.
But don't panic, because like I say, I have to give you points for your presentations.
And even the bonus questions was, oh, wow.
Oh,
True
the
or
bonus, then I think the highest of the bonus question was 2.
Say what?
Wow.
Miss Archer, Miss Stop.
I can't even laugh.
What though? Oh my gosh.
Oh.
Miss Archer said two.
Ms. Archer, you sure?
We
You
must be
gonna go over
teachers.
the paper? Are you
Huh?
going to go over that with us? So that we could know. Are you going to go over that with us? Are we going to get that?
Demetria, we can rock that baby to sleep.
No, remember what I told you all, you know, I said normally for this course, all the years I've been doing it, I just give a final exam.
Yes.
That's it. My predecessor would have done a final exam, all multiple choice. All multiple. When I took it over, I started doing short answers because I really want to see if students understand the process. Because you'll have sometimes in this class persons who want to apply for a mortgage. And so they really want to understand the process. And so they're learning it for the very first time. They don't even work in a bank. So I would do short answers. And students did very well with short answers, especially the bankers like you all. You do very well. But multiple choice, I don't know. I see a lot of exams are multiple choice. Maybe it's just the way I write it.
Yeah, I think that's what it is.
Let me see, hold on. Let me see if where did I put that one? I made a note of some that were difficult. Yeah, I did.
Miss Archer, you going over the baby, but we rocking to sleep?
No, I'm not going over. I'm just saying.
Oh, okay.
Yeah, I'm not doing that. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 questions. Y'all got wrong. Yeah, that's why I don't like multiple choice. But you all wanted it. So I'm leaving that baby to sleep. Because if we had a final exam, a lot of those type of questions would not have been on the final exam. I might have given you a question on good marketable title, but it would have been a scenario. So which do you prefer? I add on the grades from the presentations, or you want a bonus question and let me add that to the midterm?
No,
No,
go
add on the
with the
presentation.
All right. But I mean, but if some of you all feel on Monday, think about it, that you want to go over some of the questions, you can. I mean, if you, like, let's just say you felt like there was some that you really didn't know the answer to. But if you say it was the way in which the exam was delivered, then you know that you probably could have done better if you had more time to think and deliberate. Up
Yeah,
to you.
that too.
Yeah, you can let me know. But I tend not to give multiple choice for the same reason.
So with the final grade, that's like us starting from scratch, or is the midterm gonna be a part of our final?
A part of.
Okay,
Yeah, but it's not going to be that low because, like I say, everybody participated.
okay. So that will go toward our final as well.
No, the presentations, I'm going to add them to your midterm grade.
Okay, but I mean our overall, like, so for our finals, like as if we starting off from scratch, then, like if we pass,
Or are you doing a cumulative of the
yeah, like
final and the, okay.
Yeah.
okay,
Be
So what
midterm.
what you're saying really is that on average, up to midterm, class is averaging about 40%, so we need 60 to pass to make it 100? No, what is the passing grade, 70?
70.
70, okay. So we have 40, need 30 on finals.
Yeah.
I just doing the math there. Okay, I'm not
Not
saying I'm
30,
looking.
not 30 or 100.
No.
No.
I'm
Don't forget
meaning.
now, don't forget that even though your grades were 50 out of 100 for the midterm, you still have to add points on that for your presentations.
Okay,
So by Monday, I should be able to tell you all how many cases you presented. So when I multiply those by 5, you should know how much you're getting on top of your midterm grade.
okay.
Yeah. But then add for the finals, because the finals will carry more weight. Don't worry, don't stress.
Yeah, Miss Archie, you just say that, but when you're averaging 50,
It's not 50. Wait until I tell you how many points you have for presentation. That's how many cases you presented. And if you're good, you should be able to say to me, okay, Miss Archie, you missed 1, because I did 4. And that's 20 points right there, 4 or 5. So that move you from 50 to 70. Worry not.
Ms. Archie, don't forget that first one, what I do, it was 27 pages that count for about 3.
We will see. We will see. That's what I'm going to do now, to see exactly how many each one of you presented, and then y'all can tell me yay or nay on Monday if I missed any. All
Okay.
right?
Okay,
That sounds good, right?
yeah.
No,
yes,
don't worry. You will pass if you study. All right. So have a great weekend, and we will chat on Monday.
Okay,
okay,
All
bye,
right.
everyone.
Thank you.
Enjoy your weekend.
okay,
Bye.
bye.